Hi, this is Satya Kadirvel from Tamil Nadu State of India. This is a high emergency and high sensitive video message which I am addressing on 21st March 2026 to all 5 UN Security Council permanent member country leaders of China, Russia, USA, UK and France, and the honorable country leaders of UAE, Turkey, Saudi Arabia, Qatar, Pakistan and North Korea, and all 192 world country leaders and media channels and all UN bodies and International Labour Organization and International Court of Justice to please stand with me and to please help the innocent daughter of an Indian farmer's family to get justice for the very open and very high sensitive forgery email evidence planned to be submitted by EY partner Ram Deshpande and EY HR team authorities under strong influence of criminal Anand Ambani upon request of the main criminal Asokan Perisamy with the strong political support of criminal India's Prime Minister Narendra Modi. I would like to convey and highlight a strong sensitive point to all addressed country leaders that there is no future for me and my sister without getting justice for this most cruel, politically influenced and pre-planned sudden illegal termination of my EY company job, which was done by EY partner Ram Deshpande and EY HR director Hina Mudaliar under the directions of EY India CEO Rajiv Memani upon the direct political influence from criminal India's Prime Minister Narendra Modi, which he has done in support of criminal Mukesh Ambani family and criminals of Najjatar murder case. First of all, I would like to highlight a key point of my video message. So the key point of my video message is the strong criminal plan by EY partner Ram Deshpande and EY HR team authorities who are strongly planning to submit a very open and a very high sensitive forgery email evidence during the upcoming case hearing on 25th March 2025, which is coming Wednesday when I am going to file my objection petition to the IA filed by EY company respondents. Before I start, first I would like to explain that I have registered the case in Bangalore Labour Court. So after that, during the first case hearing, which was held on 6th Feb 2026, the EY company authorities have filed their third counter response petition. So before I get into further, first I would like to convey the repeated confirmation and standpoint made by the previous EY representative Shanil Mirza to me in the conciliation meetings. So when we had the Bangalore Labour Commissioner Office conciliation meetings, Shanil Mirza have made me the repeated confirmation and standpoint from his head, which is he has repeatedly confirmed to me that EY company does not have any such leave approval email sent from EY partner Ram Deshpande to me. He even asked me like if you have the leave approval communication email with you, you can come and submit to the Bangalore Labour Commissioner. Apart from this, he had made a strong repeated standpoint that EY company have only the one and only two email chain, which is the 15th September 2022 email chain followed by the next email on January 2023, and he has repeatedly confirmed that EY company does not have any other emails sent in between this period to you. And even again in the final conciliation meeting, he again made cross inquiry with him, where he again repeated that EY company does not have any such leave approval communication sent from EY partner Ram Deshpande to me. So this is the debug. So this is the conciliation meeting, first detailed response petition, which was properly represented by Ram Deshpande, and Shanil Mirza was representing Ram Deshpande and EY respondents, which was filed on 21st November. They have filed, Shanil Mirza have strongly confirmed that EY company have only the 15th September 2022 email chain followed by the 2nd January 2023 email chain. While handing over this document to me in hand, on the face he told me that EY company does not have any such leave approval sent from Ram Deshpande to me. This is the first objection petition. Again, in the conciliation meeting, on final conciliation, they filed a second time objection petition represented by Ram Deshpande, and Shanil Mirza was representing Ram Deshpande and EY company. They just added the termination letter and additional statements from their end. That's it. He did not add any other emails. So after that, this is my Bangalore Labour Court main claim petition. In this main claim petition, so I have registered the repeated confirmation and standpoint made by EVA representative, EVA HR at Shanil Mirza. I have multiple times reconfirmed. The paragraph number 86 confirmed that the attached emails from September 15, 2022 and the next email from January 2023 attached in the annex of their objection petition dated 21st November are the one and only two email communication from EVA company sent to me during my long leave, and only these two email chain are being referred as evidence emails for the stated allegations in their response petition. And I have attached a detailed conversation document number is 44. So EVA company have clearly read my main claim petition, this paragraph number and the attached document, and again they have the EVA company have consistently filed their third counter response petition again with the same 15 September 2022 email chain, followed in the sequence of the next 2nd January 2023 email chain, which they have filed on 6th February 2026. So far EVA company have filed. Okay. So far EVA company have filed 3 counter response petitions, where in the 3 counter response petitions EVA company is consistent with the repeated confirmation and standpoint made by their EVA representative Shanil Mirza, where he confirmed that EVA company have only the one and only 2 email chain, which is 15 September 2022 email chain, followed by the next January 2023 email chain, and EVA company does not have any other email sent in between this period to you. On top of this, he repeatedly confirmed that EVA company does not have any such leave approval communication sent from EVA partner Ramdesh Pandit to you. Now everything is consistent and fine with the standpoint made by their EVA representative Shanil Mirza. But now, why I am addressing this video message that EVA company, EVA partner Ramdesh Pandit, EVA HR team authorities are planning to submit very open and very high sensitive forgery email evidence in the upcoming case hearing. It's because of 3 reasons from my end, 3 evidences from my end, which is while the EVA company have filed their third counter response petition, they have filed along with the third counter response petition, they have filed an interlocutory application asking for removal of the names of the 6 respondents from the petition and to generally use Ernst & Young. Honorable court may be placed to strike, delete the second party number 1, 2, 6 and to array second party is Ernst & Young LLP as the sole party. So why sudden, why So as the country leaders can see, when I registered the case, I have registered the case against 6 respondents, which is Ramdesh Pandey, Hina Mudaliar, Sankat, Paresh Jain, Shanil Mirza and Kila Rajiv Memani. So all these, okay, back. So EVA partner Ramdesh Pandey have confidently represented EVA company during the conciliation meetings throughout that, and they don't have problem. But after filing third counter response petition, why they are trying to take this step back and they want to use they want to remove their names from the petition. They want to address the petition only in the generic name of EVA company, which clearly proves the fact that, which gives a strong suspicion ground that they are planning to submit some very open and very high sensitive forgery email evidence, and they want to submit that forgery email evidence under the generic name of EVA company, and they want to safely conceal the involvement of EVA partner Ramdesh Pandey and other EVA HR team authorities and other EVA authorities in this strongly planned high sensitive forgery email evidence submission crime, and that's why they have asked for removal of their names from the petition. This is reason number 1. Reason number 2, they have suddenly changed the very main manual witness and EVA representative Shanil Mirza with a new EVA representative. Why they have done that? Shanil Mirza is from Bangalore EVA company. He have given repeated confirmation and standpoint on behalf of EVA company throughout the conciliation meetings that there are one and only 2 email chain with the EVA company, and after I submitted the standpoint made from Shanil Mirza in my main claim petition, EVA company have also submitted the third counter response petition with the same only 2 email chain. But now, why now they are changing the main manual witness EVA representative Shanil Mirza with a new representative, which gives a strong suspicion for me that they are only it's only because of the criminal plan to submit a very open and very high sensitive forgery email evidence by going against the repeated standpoint of EVA representative Shanil Mirza. They have changed this EVA representative. And third very strong evidence from me for suspecting the very open, very high sensitive forgery email evidence is mainly because of the repeated and 100% indisputable evidence of repeated open show of crime acts done by the main criminal Asohan Perisamy in the month of January 2026, where he has repeatedly done open show of evidence to me to directly convey to me that yes, EVA company is going to submit a very open and very sensitive forgery email evidence in the upcoming case hearing in labor court. So now I will share those evidences from my EY laptop. So, the third strong evidence which I am going to submit to prove the strongly planned forgery email evidence submission by EY partner Ram Deshpande and other EY HR team authorities is the 100% indisputable evidences of open show of crime acts of main criminal Asagan Perisamy to openly show off the planned very high sensitive forgery email evidence planned to be submitted in labor court by EY partner Ram Deshpande and other EY authorities with strong political support of topmost leadership. In January 2026, the main criminal Asagan Perisamy have done multiple open show of crime acts where these crime acts are 100% indisputable evidences which cannot be dismissed as either accidental coincidence or nothing like that. So on 11th January, I have the evidence that I have uploaded in Facebook about my video message about the strongly planned forgery email evidence submission by EY company authorities by cruelly changing the original email contents of long leave approval given by EY partner Ram Deshpande and by creating any other kind of forgery emails. These two video messages after I uploaded, I have started drafting email complaint with reference to explaining these two video messages. Exactly when I was drafting that email complaint about the planned forgery email evidence planned to be submitted by EY company authorities in the labor court. So this is the usual normal display of the endpoint security software where by default the Vala.com insurance company website is by default it is selected. This is the normal display of the screen in my EY laptop. Since the illegal termination of my EY company job for last 3 years, I have never ever faced any error screen in my EY laptop. But exactly when I was typing the email complaint about these two video messages, exactly at that time, I got this sudden display of absurd error screen which never ever appeared in my EY laptop for last 3 years since the day of illegal termination of my EY company job. It says, the site security certificate is not trusted, and then in the fingerprint path it shows some words. Main catch is that it's displaying military context words such as navy, food. So Vala.com is an insurance site company. There is no way possible in the fingerprint path would generate words, military context words such as navy, food, etc. And this is open show of done by criminal Asagan Perisamy because I have lots and lots of emails where I used to send underwater navy attack, navy war to Russian defense team and other country leaders, and I have used to say give alerts about food poisoning, biowar, and that's why intentionally he displayed these words as navy, food. This open show off act of open illegal hacking of my EY laptop is just very open show off to me from a criminal Asagan Perisamy that yes, whatever you are suspected is right. EY company, EY partner Ram Deshpande and other EY HR authorities are going to submit a very open and very high sensitive forgery email evidence in the labor court by cruelly changing the original email contents of the long leave approval given for me without time limit by EY partner Ram Deshpande and by creating any other kind of forgery email evidence with any kind of false content by using the EY exited EY HR Bharti and by misusing my EY mail account in any extreme possible ways. So another show off act he has done is on 22nd January 2026, I went to Delhi and I submitted a petition addressed to the Saudi Arabia king. In that petition, I have mentioned about the criminal association between EY HR Data Shanil Mirza and Anand Ambani and criminal Asagan Perisamy. So this 22nd January submitted Saudi Arabia petition, I have attached and sent from my email ID on 23rd Jan to Saudi Arabia king. The country leaders. So after I sent from that email ID to the same email ID, the main criminal Asagan Perisamy have sent me a spam email by using a spam email ID where he mentioned about the contents of my confidential Saudi Arabia petition where I have mentioned about the association between criminal Anand Ambani and criminal Asagan Perisamy and EY HR Data Shanil Mirza. When I did not react for this on 27th January, again to make me react, criminal Asagan Perisamy have used a Saudi Arabia WhatsApp number and have again mentioned about the contents of the confidential Saudi Arabia petition where in that petition I have mentioned about the association between Shanil Mirza and criminal Anand Ambani and criminal Asagan Perisamy. So after this, I got strong suspicion that EY company is planning to do some kind of conspiracy with reference to EY HR, the EY representative Shanil Mirza, and all I suspected is that they might try to go against the repeated standpoint and confirmation made by EY HR Data EY representative Shanil Mirza. And again, on 2nd Feb, I registered accurate conversation which went between me and Shanil Mirza, for which both EY lawyer and Bangalore Labour Commissioner are direct manual witnesses. And I registered that exact conversation where repeatedly Shanil Mirza stated to me that EY company have no such leave approval sent from EY partner Ram Deshpande to you. EY company have only the 2 email chain, which is 15 September email chain and followed by January 2023 email chain, and EY company have no other email sent in between this period to you. So after this repeated show of crime acts by criminal Asohan Perisami, so I want the country leaders to please see the sequence of events. So in November and December, EY Representative Shanil Mirza have given me a repeated confirmation and standpoint on 21st November and 9th December. After this incident, I just filed a high suspicion complaint on 11th January. I submitted the video message complaint about highly suspected planned forgery email evidence submission by EY partner Ram Deshpande and EY India CEO Rajiv Memani by cruelly changing the original email contents of long leave approval given for me without time limit by Ram Deshpande and by creating any other kind of forgery email evidence by using either exited EY HR Bharti and by misusing my EY mail account in any ways. When I registered this suspicion complaint, for 3 years, the completely impossible scenario, for 3 years, no such error screen appeared in my laptop, but on the day of submitting forgery email evidence complaint, while I was drafting that complaint about that video message, the absurd error screen appeared in my laptop where the checkpoint endpoint software have been hacked and by EY company authorities have displayed that error screen. Followed by this high sensitive incident, again the main criminal Asohan Perisami has sent me a spam email and again spam WhatsApp message and phone call by indicating the contents of my confidential Saudi Arabia petition where I have mentioned about the criminal association between EY Representative Shanil Mirza and Anand Ambani and Asohan Perisami, which is 100% indisputable evidence, and this is all repeated open show of crime acts by Asohan Perisami to openly show off to me that yes, whatever you are suspected is right. EY partner Ram Deshpande and EY India CEO Rajiv Memani and other EY authorities are going to submit a very open and very high sensitive forgery email evidence in labor court by cruelly changing the original email contents of the long leave approval given for you without time limit by Ram Deshpande and by creating any other kind of forgery email evidence by using either exited EY HR Bharti and by misusing my EY mail account in any ways. Now these are all strong justified grounds of suspicion for me. What happened next? So after this January 2026 open show of crime acts of criminal Asohan Perisami, in February 2026 first court case hearing, even though the EY company submitted the third counter response petition which is consistent with the repeated standpoint made by Shanil Mirza, they have parallelly changed the main manual witness EY representative Shanil Mirza with a new representative, and they have also asked for removal of all the 6 EY respondent names from the petition and to use the generic name of EY company name in the response petition, which gives a strong suspicion ground that the EY company is doing this only for the criminal motive to submit a very open and very high sensitive forgery email evidence in the future court proceedings by using the generic company name as EY company name and to safely conceal the involvement of EY partner Ram Deshpande, EY India CEO Rajiv Memani and other involved EY authorities who are involved in this planned high sensitive forgery email evidence creation crime. And so based on this suspicion, it creates high suspicion for me that this third time counter response petition is a deceiving strategy used by EY company against me to make me falsely believe that okay, EY company has submitted again third counter response petition which is consistent with the repeated standpoint made by EY representative Shanil Mirza, and to make me falsely believe that EY company will not submit any new forgery email evidence in future, which is a deceiving strategy used against me. Another point I want to highlight is that in the sequence of events from November-December 2025 followed by open show of crime acts by criminal Asohan Perisami in January 2026 followed by the next criminal steps taken by EY company authorities, the key point of evidence derived from this sequence of events is that EY company has been illegally monitoring all my emails and all my laptop activities, and then they are deciding their next criminal step based on illegal monitoring of my emails and my laptop activities. I would like to again highlight that it's only after in January I registered a complaint in the Supreme Court of India about the open illegal hacking of my EY laptop, which is 100% indisputable evidence of the planned forgery email evidence submission by EY company authorities. And after I registered complaint against EY partner Ram Deshpande, EY India CEO Rajiv Memani and Hina Mudaliar and Shanil Mirza of planning to submit very high sensitive forgery email evidence which I registered in the Supreme Court of India. It is only after illegally monitoring all my complaint submission through my emails. After that, the e-way company have raised a request to remove the names of all 6 e-way respondents, and they have also changed the e-way representative Shanil Mirza to safely submit the high sensitive forgery email evidence under the generic company name as e-way company, and to conceal the involvement of these e-way respondents in the planned forgery email evidence submission crime. So this is the criminal motive. Having said this, what is the next subsequent criminal step that will be taken by e-way company authorities? Now, as I explained now it is clearly proved that the e-way company authorities are taking their next criminal step after illegally monitoring my emails, after illegally monitoring the contents of my petitions which I am submitting in the court, and the content of my complaint petitions which I am submitting against them, and illegally monitoring my laptop activities. Based on that only, the e-way authorities have asked for removal of their names from the petition and changed the e-way representative Shanil Mirza after I registered complaint in the Supreme Court about open illegal hacking of e-way laptop and planned forgery email evidence submission by e-way partner Ram Deshpande, even SEO Rajiv Memani, Hina Mudal and others. After that only they asked for removal of their names and changed Shanil Mirza. Now, so they are taking every next criminal step after illegally monitoring my emails and contents of my complaint petitions. Now that by this time, now e-way company have should have already identified that I have revealed their deceiving strategy in based by illegally monitoring the contents of my objection petition, and they got to know that their IA interlocutory application is of no more use, because they got to know that I will not leave the e-way company respondent names to be removed from the petition until I investigate the forgery email evidence if the e-way company authorities are going to submit any forgery email evidence. So now they got to know that their IA application is of no more use. So what will be their next step? Their next step will be to directly come and submit the high sensitive forgery email evidence as additional email evidence during the upcoming case hearing itself, and I am going to submit my objection petition. Why they are planning to submit it during the upcoming case hearing itself? Because after I submit my objection petition to IA, after that if they come and submit the forgery email evidence, it will become an obvious evidence. So their criminal plan is to submit the additional forgery email evidence, the high sensitive forgery email evidence as additional email evidence during the next case hearing itself, when I am going to file the objection to IA. To cover up to the honorable judge by stating that they are casually submitting the additional email evidence, and they are not even aware of the contents of my objection petition, and they are not doing any such deceiving strategy. This is their criminal plan. So if forgery email evidence is submitted, I will need e-way partner Ram Deshpande, Hina Mudalia, Shanil Mirza, and the main criminal Asohan Perisamy, who are all necessary respondents to strongly prove their forgery email evidence based on the evidences from my end. And also I will need Sankat, Paresh Jain and Ram Deshpande to cross-examine them in the court to prove the high sensitive wrong framing crime attempt done against me in the year 2025 to wrongly frame me under moral turpitude crimes, and to what extreme criminal extent the e-way company authorities have went to execute cruel manhandling and harassment against me, amounting to assault, criminal intimidation, criminal force, defamation, intentional insult, wrongful restraint, which they have done against me for the main criminal motive to wrongly frame me under moral turpitude crimes. So these are all except Rajiv Memani, all 5 authorities becomes very much necessary authorities along with the main criminal Asohan Perisamy, who will be added as additional respondent to cross-examine all these 6 criminals in the court to prove both their forgery email evidence creation crime and to prove their high sensitive wrong framing crime attempt done against me in the year 2025 to wrongly frame me under moral turpitude crimes. So this is what I want to convey to the country leaders, that during the upcoming case hearing 25th March, which is assigned only for me to submit the objection petition to IA, the criminal e-way company authorities are desperately planning to submit their forgery email evidences, additional email evidence document, for the only reason that they now got, by illegally monitoring my emails and the contents of my petition, they got to know that the IA is of no more use, and they got to know that I will not leave them to leave their names to be removed from the petition until I investigate and prove their forgery email evidence creation crime. So I will show one more strong legal principle of Supreme Court of India to the country leaders. I request the country leaders to please listen to that legal principle. So this is the strong legal principle which I want to highlight to the country leaders, the strong legal principle which is followed by Supreme Court of India and all other labour courts in India for dealing employment disputes. where they clearly state that termination orders must be judged on the reasons recorded in the order itself. Authorities cannot later try to illegally change or add new allegations to justify the dismissal. The legal principle stated that an order of termination must stand or fall on the grounds mentioned within the order itself. It's a well-settled doctrine in Indian labour and service jurisprudence. The employer cannot substitute or supplement the reasons later to justify their illegal job termination. So my case is a very clear case. So whatever the reasons for job termination which is mentioned in the termination email, only based on those reasons only the company can justify those reasons only in the court. They cannot try to illegally change the reason or can add new reasons to justify their illegal job termination. So what is the clearly stated reason for my job termination? My clearly stated reason for my job termination is that the company has given all possible leave support for me, and the company cannot provide any further extension on leaves to you. The very clearly stated reason for my job termination is mainly because since I requested for another 2 months of long leave support from eBay company, the company could not provide that support, and that's why the company have terminated me with respect to the clause 7B as per terms and conditions, which is a normal exit terms and conditions. Clause 7B is a normal exit clause. Only clause 7C refers to misconduct and moral turpitude crimes. The exit clause itself is a normal exit clause, and they have very clearly mentioned the reason that the clear reason for my job termination is because the company could not provide the support of another 2 months of long leave extension which I have requested, and they have Hina Mudaliar herself strongly accepted the company has given all possible leave support for me. And the only reason is that it cannot provide further extension of leave, which itself is straightforward, meaning that till that point I was under approved long leave in eBay company with the complete support given from eBay company for my long leave. Another strong evidence is that so the 45 minutes of recorded video call with the eBay HR head authority, who is a eBay leadership authority, Nitin Grover sir, who have very clearly stated in his recorded video call that the eBay company has given me long leave support from September till end of December by 2020 by understanding my family's security threat situation. And again he clearly stated that eBay company has given 4 months of long leave support, and since I requested for another 2 months of long leave support which could not be supported by the company because it is affecting the project client deliverables and creating project workload, the company has proceeded with the termination, and he clearly referred to the terms and conditions of the company. Based on that only the company have proceeded with the termination. So the clearly given 45 minutes of recorded video call with the eBay HR head authority Nitin Grover is completely consistently aligns with the official termination email of eBay HR director Hina Mudaliar. There is no space either for Hina Mudaliar or eBay HR head Nitin Grover to go back on their statements or to manipulate or change their clearly given termination reason for me. On top of that, eBay HR head authority Nitin Grover sir have multiple times very voluntarily confirmed to me that Satya, please do not think that you have done something wrong or because of which you are terminated. Do not think like that. You did not do anything wrong. eBay company did not accuse you of anything, any single thing. eBay company does not have any kind of complaints against you either during your entire tenure in eBay company or about the work you did in eBay company. And he clearly stated that Satya, your record is clear in eBay company, which is a very much straightforward, meaning that I was not terminated due to any misconduct or any other complaints against me from eBay company. It's just that I requested for another 2 months of long leave support which could not be provided by eBay company, and hence they proceeded with the termination as per the terms and conditions clause 7B, which is the normal exit process from eBay company. eBay company authorities, even neither Hina Mudaliar nor eBay HR and Nitin Grover sir can try to illegally change or manipulate their clear-cut communicated reason for my job termination. The eBay company can only stand and justify this reason only in the court. They cannot try to illegally change the reason for job termination to wrongly frame me under misconduct of eBay policy or any other reasons. It will only increase the sensitivity of their illegal job termination, and it will only prove their illegal job termination done against me. So that's it. I thank country leaders, and I once again request the country leaders to note this legal principle of Supreme Court of India, where the employer cannot change the very clearly and repeatedly communicated reason for job termination to the employee. And I have other many evidences which proves the same reason for job termination, and also which proves the forgery email evidence creation plan of involved eBay company authorities. Thank you.